So welcome everybody to these WEC conversations on the future of platform work, rethinking labor relations and relation in the digital economy after the Digital Labor Conference 2026. We are very pleased to have these WEC conversations just a few weeks after many of us came back from Geneva, where we had intense days and nights to discuss platform work and how to ensure that platform work on the one hand is a form to organize work and to organize services, while at the same time providing opportunity for business and flexibility and protection of workers. Now, we thought about whom to invite, and clearly there was a strong call to invite Stephanie Winet, who is one of the key people in the IOE who for discussions on platform work and was guiding us through the whole negotiations in the last 2 years. We are also happy to have with us Martin Klingen, Chair of Podcast Network Global for the WEConversation, and we have as legal expert Roman Gilles from EU Laboris, who is being one of our partners of the WEConversation, and he will provide some insights from the legal side on platform work and how to organize it. But before going to the presentations, a warm welcome to you all. I would like to kick off discussions on a Slido. Here you see the Slido code, and we ask you to scan the code or enter the number, and then enter just one word that comes to your mind when it comes to platform work and the ILO. So what do you think is the most prominent one, looking at the convention, looking at the discussions of the last 2 years, looking at discussions at European and global level when it comes to platform work, also when it comes to platform work and its role on the labor market? Really interested to hear from you your thoughts, and this will be feeding our discussions with our experts moving on. And please scan the code, and then we will move now to the other screen for a second. And
Michael, it says there are no active polls. Okay, now you launched it. Great.
Now I launched it. Now you can enter your keyword. Intense. Definitions. Clearly, definitions was a key element of discussions. Argument management. Some more, please. Twin Twitter, interesting. Balance. I think balance is a very strong word. I'm waiting for the employment status question. Well, of course, it has been settled now in the convention, so that might also be the reason why it's not coming up. Well, good. Small feedback here, but I think some useful insights for the discussions we're going to have. So I will stop this screen and this pool and get back to our audience. We had quite some number of people being signed up, but yeah, there's always some dropouts. Stephanie, I would like to get to you first and ask you, it's the end of a 2-year process of negotiation and discussion at the ILO, but of course there's a process that went long before, and I think we have been together in this process from the very beginning, meeting of experts some years back when we discussed for 2 days platform work and didn't reach any outcome. Then we had the first year where we spent the majority of time on the legal instrument, convention or recommendation. And I remember there already being quite tense discussion between employers, governments, and workers. Then we have the negotiations this May. It's only a few weeks back. And you look good after this intense period. But what is your take? What is your assessment of the outcomes as we stand now?
Thank you, Michael. That was a good summary of the whole process, and I think you described well that this started in 2022. So this is the end and the starting point of something bigger that is to come, I think. And I didn't put my word, but my word in the Slido would have been extraordinary, because the whole process was extraordinary in terms of time, in terms of employers' preparation, in terms of media attention, in terms of public attention. So this ILC conversation was really extraordinary on many aspects. Our overall assessment from the IOE is rather positive. Really, we're coming out of this negotiation with a positive spirit. You set some of the context. We went into difficult negotiations with very divergent starting points, with the workers on one side, employers on the far opposed side. And this conversation was placed on the agenda in the context of a rapid expansion of the platform economy across all regions of the world, but with different speed and pace of technological development in every region of the world. Digital labor platforms have become an increasingly important source of income generation, entrepreneurship, labor market participation, and access to service. So this was our positive angle to this conversation. But at the same time, we also recognize that this growth has raised important questions concerning labor protection, social security, occupational safety and health, and the use of technology in the management of work. And those are all things that, you know, the workers came quite strongly on with. So we would have preferred to have a recommendation. And as you said, last year, we spent a week discussing the form of the instrument. We would have preferred a non-binding instrument. We now have a convention, which is binding to the governments who will ratify it. But it's considerably more balanced, and balance was one of the words in the Slido. It's considerably more balanced and adaptable than many of the proposals that we have seen during the negotiations. So the final text now preserves flexibility for implementation at the national level and avoids several approaches that could have really undermined innovation, entrepreneurship, and employment creation. So just also to remind all of you, throughout the negotiations, the employers group, we had really four guiding stars and principal objectives that really drove us through the negotiations. One was that we wanted this convention to highlight the diversity of legal systems, of labor market institutions, sectors, and business models that characterize the platform economy. This convention was not meant for us to regulate just one portion of the platform economy. And for instance, we all think of ride-hailing platforms. The scope is broader, and we really wanted to preserve that. The second objective that we wanted was to safeguard the distinction between employment relationship and genuine self-employment, and opposing any presumption of employment, preserving clear distinction between existing labor framework and commercial law. So this was for us something that we needed to preserve throughout, and I think we have. And the third objective was to ensure that the convention supports innovation, investment, entrepreneurship, job creation. And here we were really happy that we were able to add two clauses that really set the tone for entrepreneurship and business creation. And then the fourth objective was really ensuring that the provisions related to technology, and in particular to automated decision-making systems, remain practical, proportionate, and capable of implementation. So implementable, as we said throughout the negotiation. So really overall, our assessment is positive because our 4 objectives, we were able to follow them, and overall a positive assessment, Michael.
Thank you much. And I think this is being broadly shared by our industry. For us, of course, the employment status question was an important one. And I think also there we have gotten a nice outcome, a good outcome. Martin, we have been following platform work for many, many years at WEC, and we have been following discussions at the European level of the EU Directive, at the global level of the ILO, and you have been very much engaged in the discussion in Geneva. So what is your take overall on the outcomes of the ILC and on the convention that was adopted? What is your main take on alcohol management, on the employment status, and on the other main provisions in the convention?
Yes, thanks, Michael, for the question. But first and foremost, let me say a big thank you to Stephanie, to Eva as our spokesperson, and the entire team for the tremendous work that you put in the preparation, but most importantly into the negotiations in Geneva and in this year, but also the year before. It was very, very intensive and much time invested. So thanks a lot for this. And reaching an agreement on a convention is a sensitive and complex area, so it's not a small achievement that you made. So my congratulations to everyone involved for getting this across the finish line. From my perspective, the intensive discussion between governments, workers, and employers' representatives can be described, as we said before, as with a balanced output. It's not perfect for any side, and so this is often a sign that the outcome is workable. And for us as a HR service industry, as you said, Michael, there are 3 particularly relevant elements: is the provision on employment status, the use of algorithms, and the question of fees for job seekers. Let me start with the employment status and its classification, because the final text is a step forward, because it reinforces a principle that we consider as essential, because the classification should primarily be based on facts, by the reality of the work relationship, but in addition to this, also by other facts and other situations. So it's better to have evaluation based on facts than by labels, by formal wording in contracts, by business narratives. And this is, I think, we will hear later, crucial also for legal certainty, for enforcement, and also for fairness. And it avoids that the convention would undermine, as Stephanie already said, the business models that we have, the very diverse business models that we have in platform economy across the world. In our view, this reality-based approach creates room for differentiated solution, protection where protection is needed, on the other hand, flexibility where flexibility is justified. And this matters especially because platform economy is not a single model, as Stephanie also said. It's a very diversified market. Discussing with politicians, also in my home country in Germany, it's always focused and reduced to delivery or driving services. And there, looking only into this, I can understand the request for protection, but we have also this high-skill project-based work, IT assignments, creative services, etc., and many, many more. And these very, very diverse segments have a different degree of dependency on risk profiles, of bargaining powers, etc. So if regulation would have treated platform economy as a homogeneous category, it would be not practically for the implementation. So we would have either left people unprotected in vulnerable situations or imposing reduced opportunities. So this is what I appreciate, even if the convention takes a little other route than the EU directive, which is already in place and will be implemented in several countries, and of course Europe at least by the end of this year. Nonetheless, it's a big step forward and should not be underestimated. And of course, the work is not yet done. Now it depends on who will ratify and how the countries on regional and national level will implement the convention into national law. But as this industry, as especially platform economy is also working across borders, it's important to have, let's say, a common baseline. Second key topic, as I said, is the usage of algorithm. And of course, we all know this is highly controversial and probably will also remain highly controversial. I think we put much effort to reduce this to the usage of algorithm and not the general usage of IT tools, which was probably a request also for worker side, but we put it down to the algorithmic management of decision-making process. And of course, this affects not only technicality, but affects the heart of work, because it's allocation of tasks, allocation of pay, waiting, suspension. So this is of course a challenge. It's now the challenge for the policymaker to regulate it in a proper way with transparency, accountability, but also fairness, without freezing technology in place or blocking innovation. And this innovation, this technicality of algorithms is a very rapid process. So I think it's not easy for a convention to regulate something that is developing in such a fast way as we've seen the development of AI-driven tools. So we need the convention had to put some basic principle to give some guidelines, and this is the output that I think we see now in the convention, which is really useful. Third topic, also especially from our industry's point of view, for us, it's one principle is very clear that job seekers should not be charged fees. At the end, regardless of the job model, this is a core element of our recruitment industry and also of decent work. And yes, we would have preferred to see a little bit of more clarity or have it more explicit in the convention, because we perceive that clarity supports compliance and makes also easier the enforcement. But even so, we will continue to advocate for this standard and promote good practice across our membership. So from our point of view, I think we have a good outcome, very balanced outcome, very balanced compromise. And so we are reasonably satisfied because the outcome recognizes the diversity in the world of work and creates a first global baseline.
Thank you very much, Martin. And I would like to get back to Stephanie for one moment, because indeed there are a couple of key issues being raised by Martin, which were under discussion in the last weeks during the ILC. Employment status, non-charging fees to job seekers for work assignments. Clearly, there is a definition question of which fees are we talking about. So besides your general assessment, which you gave very clearly, what is your take on the core provisions that matter to the HR service industry on employment status, algorithms, and not charging fees?
Yeah, so absolutely the classification and the employment status was the most politically sensitive discussion that we had, because it was the foundation of the whole convention, and of course, and of the whole balance that we were trying to strike. So how to protect the workers, but also the self-employed, the independent contractors. So by extension, also how to protect the employers and their sensitive data and all those things. So that classification and the employment status was really key in the whole process, and that's why it's this one article that was really we fought for it for quite a few days, and of course significant differences emerged among constituents regarding the relationship between worker classification and access to labor protection. Several proposals sought to establish mechanisms that could have led directly or indirectly to a presumption of employment, which we really fought hard against. So we constantly maintained that the classification of digital platform workers' status in employment must remain a matter of national law and practice, because many jurisdictions have already systems in place, and we would not want them to have to redraft their whole regulation because of this convention. So that's why we wanted to have something very principle-based and flexible. And we also wanted that the convention acknowledge at equal levels of importance the existence of an employment relationship, self-employment, or sometimes third categories, and not giving any special weight or any special attention to any of those categories, because it exists. We need to recognize and it needs to be acknowledged. So we're happy also that this is acknowledged and this diversity is acknowledged, and we're not just going into all platform workers must be employed, full stop. So this is something that we're really happy about. This final convention preserves really a broad scope that covers both location-based and online platform work, and it avoids introducing a single international model for the classification of digital platform workers. It recognizes that employment relationships, self-employment, and other legal categories may exist under national law and practice, leaving member states the flexibility to determine the appropriate classification of platform workers within their own legal systems. So these negotiations ultimately centered on preserving this flexibility while ensuring that the workers have the appropriate classification in accordance with their legal status under the national frameworks, and then have the protection that go with this. Another hot topic, which is very much linked to that, was the working conditions. And we also devoted quite some attention to issues relating to working conditions, payments, remuneration or payment, occupational safety and health issues. And all those discussions very much applied and were dependent on this classification conversation, because of course, employees don't enjoy the same benefits as self-employed, or the other way around. And for us, it was really important that measures aimed at safeguarding working conditions were there, while emphasizing the need to respect also this distinction between employees and self-employed persons. And we gave particular attention to ensuring that provisions traditionally associated with employment relationships would not automatically be extended to independent contractors, irrespective of their legal status. And there was a try to have remuneration, minimum wage, extended to self-employed. So this was for us something that we would not be able to accept. So this text now seeks to promote decent working conditions while preserving coherence with existing national regulatory frameworks. It really clearly distinguishes between the different legal categories of workers, and then it avoids the automatic extension of employment-related rights and obligation to the self-employed person. And maybe, Michael, the third hot potato was really this tech point, automated decision-making system, and the increasing use of digital technologies, including automated decision-making systems in the management of work. This was for us something that we really wanted to preserve. There was already one article that was agreed upon last year, and now 2 additional articles were added to the convention. For us, it was really about securing a more balanced approach to automated decision-making systems, which, let me remind you, initially implied that those automated decision-making systems can cause OSH risks and human review requirements, and having human review for all decisions pertaining to working conditions and access to work. So for us, this was really something that we needed to water down. So we were able to keep an appropriate human involvement at company level in the text, which is now more implementable than a human review of all decisions pertaining to working conditions. Another point was the fact that we could preserve an important limitation to access to information on decisions generated by automated decision-making systems. Only the worker and not the trade unions or the worker representatives, as it was originally drafted, can have access to a written explanation. And this must be only significant decisions that adversely impact working arrangement and access to work. So not any working conditions points. So those are, compromises that we were able to find to be able to find a consensus and to safeguard some of the clauses. Also, when it comes to protecting commercially sensitive information, intellectual property rights, proprietary technologies that we wanted to preserve at all costs. Again, it's also about making sure that companies can continue to use platforms in a way that would not refrain them from doing business. And for us, this was really a key point. Our central objective was to avoid creating obligations that would be really impractical to implement or that could undermine the ability of platforms to operate effectively in really highly competitive markets.
Thank you very much. A lot of feedback, ideas, and insights, Stephanie. I would like to turn to Roman here and getting a bit the insights from the lawyers, because we have discussing a lot of legal issues, a lot of legal questions. And Spain, the country where you are based, Roman, is one of the countries that has been moving ahead with the law on riders, so on one classification, one kind of platform work. And of course, Spain will have to review its law based on the EU Directive, based on the convention, if they're going to ratify. What is your take on platform work in Spain and in the light of discussion in Spain regarding the ILO convention?
Yes, well, unfortunately, I have to say that our experience has not been very good, and that precisely for not having done what the convention has done. Stephanie Winet has explained it very well, what happens when you have an inflexible position, how it can damage the possibility of companies to operate without exploring ways of protection and organization which could be manageable. What did Spain is to be very prompt, went very fast and legislating it has been written, the most aggressive instrument in the world. The Riders' Law, as it is called, wanted to be the first one, which is what happens also when you want to regulate something without getting into the nuances. The intention was to protect, of course, employees or fake employees who could be rendering services within platforms. But what they did is to create a status-based protection system, which is extremely inflexible. And that not only by setting the law, but by being very also aggressive on the part of the labor inspection, which is it has shown a very relevant lack of flexibility and has already expelled important players in the market who can simply, not just from an economic perspective, which is not just or not at all, in my opinion, a matter of saving monies or contribution to the social security, but adapting protection and organization in ways which could be peculiar to this new way of rendering services. So what happened in Spain is it has generated, it has expelled some relevant actors from the market. Deliveroo is a clear case, or has generated years of what has been called years of attrition, of a lot of litigation and a lot of unrest for years already in the market. Then many platforms who are trying to render services in these companies who are using platform work have moved to fleet subcontracting structures, which in many ways, the experience, what we are seeing, the employees are not necessarily better protected than they could be with a more flexible regulation like the convention, but are being monitored very strictly and are not being getting more income, often less. And also, even in cases of very famous cases, very open cases in Spain is very well known, the Global case, where there are very large fines and even possible criminal actions by the government is, telling the companies they're going to fight criminal actions, the Ministry of Labor in Spain. And the reclassification has still generated lots of litigation. It's not a simple solution because reality is tough or stark. Tough, I don't know if that's the right way, but reality is what it is. And this is not simply my impression, and as a lawyer, I've been acting for some of these platforms, I must say, but really, seen from the outside, this is not just a matter of saving money and trying to evade the application of a protective, but it's trying to adapt to a different way of working, which is, and trying to explore other ways of providing both protection and at the same time the ability to organize this new way of rendering service is something that deserves a more open, more nuanced, in my opinion, a more experience-based ways which can be diverse. So if I could summarize, I would say that Spain's lesson for companies everywhere is blunt: is the cost of defying the trend is not avoided, only deferred and compounded. The conditions battles outlive the classification battle. If everything is about classification battle and not about, as the convention does, which is, classification is guided mainly by facts, but notwithstanding the facts, notwithstanding classification, let's give some protective floor to everyone. Core protection of occupational safety and health, minimum wage, social security, protection against deactivation and termination, and let's not get lost into this more stringent or more inflexible classification conundrum, which may end up in damaging many companies, expelling companies, destroying employment without necessarily ending up with a better outcome. To just finalize, I would say that the same thing could be done with more flexibility, still protecting and getting the job done. So Spain is, unfortunately, I think, not a good example.
Thank you very much. And I have a bit of a similar view on Spain, but we are not here to discuss only Spain, but we are looking at a global instrument. And I'm turning back to Stephanie, because we have been discussing and advocating for a principle-based convention that serves the needs in developed countries, economies like Europe, US, but also regions like Africa and Asia. And that's a challenge of the ILO. We need to find a way that serves all countries globally, but still has a meaningful content. You refer to a principle-based convention. How do you see the outcome in terms of serving the different countries and geographies around the world? And how do you see the chance of this convention reaching a higher level of ratification compared to other instruments?
Well, indeed, it needs to serve 150 countries with very diverse contexts. As I was saying, also the pace of technology is developing at different speed, and the access to technology is also different from one country to the other. The legislation piece is also very diverse. EU has its act. Spain has now also its regulation, successful or not, to be debated. And Spain is not the only example, that we were able to bring during the negotiations, which failed. And we had also very concrete examples of a change of legislation, very specifically to Geneva, where as soon as Geneva decided to have all platform delivery platform turn into employees, small platform companies had to shut down because it was just not sustainable. So we really have examples of companies who had to shut down a business because it was not sustainable. So this is something that for us is really difficult to see. Now, this convention, principle-based convention, needs to be applicable, adoptable, ratifiable, workable for countries in Africa and Latin America and Asia who don't have existing laws and who will rely on this convention now to guide them. So they will come home with this convention, ratify it, and they will need to create now their systems. We believe that this convention will be enough to guide those governments, in particular those who don't have legislations in place, to have, again, to let them also see in their context what is feasible, what is not feasible, to see whether a Spanish model would work for them or not, to see whether a Mexican model would work or not, to see whether India, with the third category also, is something that African countries could work with. I think we have given enough flexibility with this convention for those governments to have a menu of opportunities and see what would work. For us, it was really key, and we've highlighted this many times. The continent of Africa has a youth population entering the labor market, which is huge. The labor market is not able to absorb them. So now they must they have to put in place systems that allow that young generation to have access to employment, job, work opportunities, and maybe the platform will help. But that's how anything that those countries will draft in terms of policy making should be mindful of employment creation and of company creation, of making sure that they can have enabling environment. And this is something that we keep saying, enabling environment for companies to be able to be set up, be able to set up shop, be able to set up a platform for them to be able to create all those opportunities. And we do believe that this convention will assist them adequately.
Thank you very much. Turning a bit back to Europe and to what's happening in Europe. In negotiations in Geneva last year and this year, I remember there was quite a discussion on this convention not to be too European-centric and not to copy the EU directive. Now, the way I read the convention and the direction, I still feel that they are complementing each other, and it would be possible for European countries to ratify the convention, even though they are obliged to ratify also the EU directive. So, Roman, I would like to get your assessment as a lawyer. How do you see the interaction between these two legal instruments, and have we managed to find a solution that works for Europe and for the world?
Well, there are very, very, very relevant differences between both tools, regulatory tools. First, a very clear one is regarding nature and effects of both regulatory tools. The convention is a classic international convention, so it binds states that ratify it, and it enters into force after two of them have done it. Its effects are deferred, and it's conditional and are mediated by the state will. However, the directive, as everyone knows, is secondary EU law, so it's binding to the result with a fixed transposition deadline, primacy, vertical, direct effect, and when it's sufficiently precise, it's applicable directly to in the countries. So the directive is more operative, more imminent, and the convention is a global normative signal with slow deployment. That's a very first relevant difference. Classification differences, that's where I think it's the main difference between both, and extremely relevant, because the convention regarding classifications requires ensuring correct classification, it says, guided mainly by facts relating to the performance of work and remuneration. And it enshrines the primacy of facts, but without a presumption of any reversal of the burden of proof. However, the directive, Article 5, has a rebuttable legal presumption of employment relationship when services are rendered in a platform triggered by control and direction. So the directive is substantially stronger and procedurally operative. This is key. Then, regarding what I call the coverage architecture, Both instruments share the logic of what could be called a universal floor. That it's that certain rights apply irrespective of classification. For example, the convention, that floor covers fundamental principles and rights at work, health and safety issues, violence and harassment, data protection, automated system, and the prohibition of account suspension or the activation of unlawful grounds. But it reserves other rights to those in an employment relationship, notably minimum wage and so. The directive follows a very similar architecture in this sense. The algorithmic management chapter reaches everyone doing platform work, even if you are not an employee and you are genuinely self-employed. Then, regarding algorithmic management, the directive is clearly ahead because the convention operates in a generic register, prior information on automated systems, responsible use, or written explanations of adverse decisions. However, the directive provides very substantive limits on the processing of certain data, for example, emotional or psychological state, forbidden private conversation, predictive biometric data, indication of trade union activity. It requires an impact assessment, human oversight of the systems, qualified human review of significant decisions, and a prohibition of decisions to terminate or suspend based solely on automated processing. Thus, it's very different between both rules. And finally, this is relevant for what has been discussed before about this diversity of countries being affected. There is a universal vocation of the ILO conventions versus an internal market with a more homogeneous regulation in many aspects. So the convention has what has been called the ILO's stamp, which is it covers the informal economy, the formalization of self-employed work, the protection of migrants and refugees, and addresses cross-border work. However, the directive operates over formalized economies within the Rome I and Brussels I bis framework and needs no such apparatus. On social security, both systems converge in deferring to national systems, and both avoid hard harmonization regarding payment, regarding salaries. So at the end, the directive is closer to a law, closer to a binding, very clear, more restricted, with a presumption of employment, and the ILO convention is broader. How will this apply in different countries? For example, in the case of Spain, we were referring before, and the were similar, it will have no effect whatsoever because it's already way beyond that. And in general, I would say that in the EU with the directive, which is not yet transposed in many countries because it ends by the end of the year. But my impression is that with the coverage of the European, the effects of the convention will be very limited. That's my impression, but not in the rest of the world.
Clearly, and I mean the one thing that I was concerned about, whether the convention could be incompatible with the directive in certain provisions, preventing EU countries from ratifying. But my reading is that this is not the case. I mean, of course, on the employment status, the EU directive goes much further, as you said, Roman. But in the end, the classification elements in the convention are still ratifiable, even though the EU directive goes further. So I think we managed to get an agreement that preserves European interest by keeping a global principle-based approach. Mm-hmm. Martin, what you have heard so far from our two guest speakers, is there anything you would like to add from an HR services industry point of view?
To add, I think we've already said everything. The 3 points remain. Yeah, that with the convention now we have a global common framework, and now it's time to implement it on a national level. And what's really to be highlighted is the convention gives some clear guidelines while remaining the flexibility for the national implementation, reflecting also the realities of the labor market, which for sure are very different across countries, or especially also across continents. We have some clarity for the employment status based on facts and no pre-classification, and this was for sure one of the most important outputs. The algorithms are not just a tech issue or something that lies in the heart of the working condition, as I said. So just to summarize a little, we have protection and fairness and flexibility, which will support the sector's development. And this is crucial to have manageable regulation and reflecting the diversity of the business model, with always one aim to foster the creation of decent work across all forms of economy.
Thank you very much. I would like to turn to our audience online or behind your desks. And I see on the list a few people who would be really interesting to hear from. One is our employer spokesperson, Eva, who I saw on the participants list, and I'm really happy to give her the floor. But also Mina Meleri, my director, if you have some remarks on what you see as key elements of these discussions. Eva, are you with us?
Thank you, Michael. Great to see colleagues online, and thank you also for the kind words. Look, I think this crew really covered it well. I think the analysis by all three is pretty spot on. I would just say that I think it's a really big deal that this standard really embraces more flexibility within the labor market. And I think for the WEC community in particular, that's a really big win. This is not a, as Roman said, this is not a strict standard the way the Platform Work Directive is, or the way certain national laws like the Writer's Law is. And so really this this acknowledgement that you have different classification types within the platform economy is really important in order to continue political support for flexibility in the labor market. So I would flag that as one big win. And then the other thing that I also want to echo is that, you know, there was a risk that this standard could have created a brand new classification test at the global level, and that didn't happen. And I think that's also something for us to bear in mind, that implicitly this standard has said that, yes, you need to have appropriate classification, but let's follow existing national laws on that and not uproot that at the global level, which in some ways is also where the Platform Work Directive landed. So I think that in and of itself is also a very, very important outcome. You know, on the Platform Work Directive, I think all of your reflections were pretty spot on. The way I like to summarize it is to say that it's very much, the standard is very much compatible with the European Platform Work Directive, but at the same time, there are certain components in the Platform Work Directive that were outright rejected at the global level. And I think that is also something that I recognize that we have folks on the call, not just within the WEC community, but more broadly. But this is quite important because for a long time, we've seen this pattern that outcomes at the ILO very much mirror exactly European laws. And I know many of you on the call have business operations in all corners of the world. So it is a big deal that, you know, the European kind of approach was, to some extent, at least on certain provisions, really firmly rejected, including on the presumption of employment, but of course on the extent of the tech governance on algorithmic management. And maybe as a way to wrap that up, I do think it's also a really good outcome where we landed in terms of the tech governance that is within the standard. And Stephanie also touched on this. I think this standard could have been extremely challenging to implement if it went too far into the overlapping area of technology and labor issues. But where we landed is quite balanced, as someone said on the Slido, where, for example, on the human engagement, the requirement is really just to have human involvement at the company level. So again, I think the slippery slope on those issues within the ILO at large is, you know, a challenging one. So I think where this landed was ultimately a very good spot that protects many different businesses within the WEC community, but also within the broader employer community. So those are my 2 cents, but overall fully aligned with what has been shared by others.
Thank you very much, and very much aligned on these points and on these conclusions. I would like to turn to our members and those on the call. Of course, for some of you, ILO discussions might be what a former board member of mine told me to be a far from a bed show, very distant discussions. But of course, these discussions matter because they influence regulation at the national and European level, and also discussions happening in the countries. So is there anybody from Germany, from other countries who would like to take the floor and share insights on how you assess the discussions on the directive and on the convention? If not, Mina, maybe you say a few words on the WEC perspective on the outcomes and on your takeaway. You have also been there in Geneva during the last 2 weeks in June. So what is your take on the outcomes?
Thank you, Michael, and thanks everyone, and in particular those who were actively contributing to these negotiations. Well, I think it's a remarkable win for multilateralism, and in particular for the ILO. I think those institutions today need success stories like this, that there was a conclusion to this negotiation. It's very important for the continued support of the ministries and the governments around the globe. It seems to have been also a win for the workers' side, and I see there is Union Europa Virte on this call as well. So the reactions after the conclusion were positive from the workers' side, and based on our assessment, also the employers seem to be satisfied. So it is an outcome which was important to reach, and an outcome that is indeed balanced and satisfactory for all sides. And now for the ratification and the national implementation, we look forward to the next steps. But I would say the overall high-level assessment is positive.
Thank you very much, and pretty much shared. Without wanting to be people on the spot, but Birte, as you are on the call, maybe you can say a few words on the trade union assessment on all discussions in Europe and globally, because I know that you have been working for the ICT sector for many years. You have been a trade unionist for many years in Brussels. Maybe you can share a few sentences on the outcomes of the ILO discussions. Bitte? Well, if not, I would like to get back to Stephanie on something else, because in the context of the ILO discussions and preparation of this ILC, there was a DG report on another big topic of discussions at global and European level, which is the broader discussions on AI at work and the use of algorithms at work. And of course, we discussed it already in the context of platform work, but I would like to get your view on, is this going to be the big next topic for the ILO? And what is your assessment on the direction of travel? Are we heading towards another convention? Are we heading towards a recommendation? Is it too early to say? What is your take?
No, so on that topic, on the ILO DJ report on AI, it was indeed a big report, and I think a timely report, because AI is on the lips of every organization and of every also business. And I think that the technology is there, and now it's about how to implement and how to put together the infrastructure that would enable company to use it at its best, and also train and upskill workers to be able to use it and use it for them to be also more productive. So I think it's a big topic for the ILO. It's a big topic for many. So it's also a good sign that ILO is looking into it. ILO has also an observatory on AI, which is also up and running. So this is something that is just the beginning. Now, to what extent there's going to be a standard process on that, it's not foreseen anytime soon. Not in the coming years. The agenda for standard setting are set quite in advance, and AI should not be on the agenda anytime soon.
Thank you. I would like to turn to the audience the final time for any questions, comments, reflections, or the other speakers, if you have anything you would like to share, contribute, or say.
Well, Michael, if you'll allow me, I'll be happy
Sure.
to briefly make a few comments as well, because, well, first of all, I'd like to echo what Martin already said, which is big compliments to the IOE team, Stephanie and all the others, as well as to Eva and the entire team of negotiators who were on the ground. I think, indeed, it's been really a unique experience, as Stephanie said, and a unique opportunity for the ILO also to show that it can still be relevant in the 21st century on a topic that is very controversial. There was almost no outcome, and yet in the end it did work out well. So I think, you know, that's only a compliment also to the willingness to compromise and the creative thinking of all those involved. The one thing I wanted to highlight is the fact that this convention is also very much balanced, not just from an employer versus workers perspective, but also within the employers and specific to our industry. I think there's a few outcomes that really align with how we as a sector approach these negotiations in the last couple of years, right? So for us, of course, what is very important to us and what has always been very important to us is to focus on having a level playing field. So making sure that we do not face any players who circumvent rules that do apply to us by claiming that they are platforms and therefore going about it in very different ways. And I think this convention really upholds that idea of making sure that if you are in a de facto similar situation, there also needs to be appropriate classification. And that was not a given from the start. So I think that's also a testament to the balance and nuance that this process has brought. So yeah, compliments all around.
Thank you very much. I couldn't have said it better. I think this was a very insightful and useful exchange. Not the end of discussions. We have now the ILO convention, we have the EU Directive, we have discussions that will start in many countries or have started in many countries on how to regulate platform work and how to, on the one hand, benefit from technology, benefit from flexibility, but also ensure protection of workers that is there to provide decent work, as it says in the title of the convention. This is also to be last WEConversation. It's the last WEConversation before the summer break. But we will come back in September, and then we'll touch on another important topic, which is talent mobility and talent migration. We know that for many economies, attracting talent, retaining talent is key. And we are going to publish in September a report on labor mobility and talent mobility, showing on the benefits of mobility. And actually in the convention, there was also a provision on migration and migrants and platform work. So you see, in a sense, there's a bridge to September. I would like to invite you all to come back to our next conversation. I would like you to thank our speakers. I would like to wish you all a very good summer, and thank you very much for coming.
Thank you very much.
Thank you.
Bye-bye.
All right.